All right. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning. We welcome council and all those watching on our live stream this morning. Would ask Mr. Doug Shima to please call the 10:30 dawn.
Thank you, Honor. The 10:30 docket for Monday, May 12th, 2025 consists of one case, appeal number 128275. The Cooper Clark Foundation individually and on behalf of all others similarly situated versus Scout Energy Management LLC, certified question.
Rex Sharp, and with me is Scott Goodger. We represent the plaintiff, Cooper Clark Foundation. We're present and ready for argument.
Thank you, Mr. Sharp.
May it please the court, Robert Kirkendall, and with me at council table is Chris Brown of KL Gates, and we represent the defendant, Scout Energy Management, and other Scout entities. We are present and ready for argument.
Thank you.
Your Honor, this case is scheduled for 20 minutes each side. We're ready to proceed.
Thank you, Mr. Shima. Mr. Sharp?
May it please the court, Rex Sharp on behalf of plaintiff appellant, Cooper Clark Foundation. Chief Justice Lukert, may I have 5 minutes for rebuttal?
5 minutes is granted. Thank you.
Hope everyone had a happy Mother's Day. I would like to address a couple of things. Marketable condition rule in Kansas, the undisputed facts in this particular case, and the proposed changes to the law that Scout proposes, as well as remarkably changes to the facts. So let me begin with the marketable condition rule. The marketable condition rule in Kansas is set forth in Faucet 1. It's good law. There's no need for any change. The open question that was represented in Faucet 1 is because it is fact dependent what is a good faith arm's length market sale. It can be a wellhead condition, as this court found in the stipulated facts of Faucet 1, and refused to allow me to change that in Faucet 2. And of course, in Cooper Clark versus Oxy, the interstate pipeline condition was at issue, and Faucet, as the law, made swift and clean work of that case as well. It works even in the rare case, like Sternberger, where gas can be in marketable condition before it actually reaches the location of the market, which distinguishes Kansas law from the more onerous, I suppose, law, at least from the producer standpoint, of Colorado and West Virginia, that doesn't have that proviso that Sternberger puts in. So the law is balanced. It depends on the facts. Sometimes plaintiff wins, sometimes plaintiff loses. The undisputed facts here, the gas contract is a good faith and arm's length transaction here. No one disputes that. Neither side disputes that. Scout chose that downstream interstate market, quote, to get better prices for Scout and plaintiff, unquote. Page 2 of the response brief to this court. As it must, because that's its duty, is to get the best available price. It skipped over any other markets that might exist to get the best available price. That is, in fact, the chosen or intended market. It's chosen by Scout. It was intended by Scout. It is represented in the gas contract, and that is a good faith arm's length deal.
Mr. Sharp, let me stop you there. I've been struggling with the terminology that your side's using about intended market. I mean, it seems like it ought to just be the actual market. I mean,
I get it.
there's nothing intended about this. There's a contract and it's there. What I struggle with is whether, because their contract exists, downstream, whether your argument is the rest of the provisions in the lease don't matter because the gas title's passing, the gas is being sold, at that particular point in time. So am I reading that right? And I realize you say that if there's an express provision, but there can even be implicit provisions in the contract by the parties. And I read what you're saying as those don't matter because, unlike Faucet One, where they had the sale at the wellhead, you've now got the sale downstream. And so, we ought to be done. Am I making sense here?
You are, and maybe your point is, let me make sure I'm on the same wavelength here, that instead of intended or chosen market, it should just be the contracted for market. Whatever was contracted for, that'll set the price for whatever the gas product is for that particular market. So maybe just contracted market. Do the other terms and conditions matter? Well, of course they would, because that comes into the good faith issue, whether those terms and conditions impact the good faith or even the arm's length part of the contract. But here, there's no dispute about the good faith and arm's length nature of it. Whether it's chosen market, intended market, or as Justice Biles points out, contracted for market, it's still the best available price. That's where the flag is planted. Everything pre-sale to that under Faucet cannot be deducted. Everything post can.
Well, let me drill down maybe on Justice Biles's question a little bit further. So some of these leases, for example, the other terms or the other language in the contract is royalty payments based on the market value at the well, right? And then there's a sale downstream, right? So are you suggesting that under the marketable condition rule, any expenses to get it to market cannot be deducted? Or are you suggesting that, no, we have to read at the well and compare the market value at the well versus the royalty payment that was issued, which was at the market or whatever. And if they don't align, that's your damage calculation and the breach of this implied covenant. Do you understand the difference?
I think I do. Let me see if I can respond. So the implied duty to market is in all of the leases, regardless of whether it has at the well language or doesn't have at the well language. At the well language under Kansas law is not a valuation point. Market value is, proceeds is. That's what you would think of in terms of value, whether it's going to be proceeds or market value. So at the well,
but at the well, does that not have a meaning in terms of the market?
it absolutely has a meaning, but that meaning is it's a measurement point. At the well, the gas is measured. So it is both measured for quality and quantity, and that's what you get paid for. You don't get paid for something that's added later on down the line. You don't get anything extra. You just get what's at the well, and you get the market value or proceeds wherever those are realized. And for instance, in this case, that's realized at the Southern Star quality standard under the tariff. And so that's where market value will be achieved. That's also, interestingly enough, where proceeds will be achieved because we don't have price regulation anymore. So consequently, the implied duty to market is in all of the leases, unless, of course, there's an express deduction lease, which we don't have in this particular case.
If that's the case, Mr. Sharp, then isn't the answer to the federal court's question, which is why we're here, neither? It's not either of those two choices. It's going to depend upon the facts and the provisions of the lease.
Absolutely, that's the open question. It depends on what the facts are. Here, the facts are undisputed.
Let me just say, there's over 6,000 leases.
There's many leases here, but there's only one sale contract. And so those 3,500 wells all go through a processing plant. There's two processing contracts. They're both Scout processing contracts because Scout owns the processing plant. And then they coalesce and there's only one Scout SEMA contract for purchase.
Right,
So
but that's between, that's gonna be between the, now I'm starting to get confused, between Scout and, you know,
whoever
like,
buys it.
Cooper Clark's not part of that, right?
That's correct.
So, but we're talking about the leases between Cooper Clark and Scout, right? And there's 6,000 of those,
No,
right?
there's 6,000 leases in the entire class. And all of those leases have the implied duty to market, which unifies them all.
Well, it unifies them all, but they all use different words like gross proceeds, net proceeds, market value. So doesn't that go to what Justice Biles is saying, that there can't just be one, legal rule based what's marketable? It's a fact specific question for each of those 6,000 leases?
Thankfully, the implied duty to market is in all of those leases, even if their express language is different, unless it's an express no deduction lease. And there are some of those that exist in Kansas. They're not in this class. But in this case, all of them that unified are implied duty to market. Doesn't matter if their language is slightly different. The implied duty
It
to
does
market.
not matter. I don't understand that, because it's implied,
Correct.
the implied duty to market. But if there's express language, like we're talking about net proceeds, we're talking about gross proceeds, we're talking about, the market value, at a particular place. I don't understand how, I guess, the whole commonality when you've got so many different leases.
Well, that's something that's been litigated for many, many years. And so for almost 60 years, since the advent of the Gilmore case back in 1964, the implied duty to market has been found in all of the various types of leases that you just discussed. And the reason for that is the duty remains the same for the producer to get the best available price, to make sure that all of the gas is in marketable condition, which means not just move to the source.
And I understand that, and that's the legal question, but doesn't it turn into a fact specific question of what the implied duty to market means is based on the facts that are in the contracts, the leases?
No, because the implied duty to market goes across all of the leases. The implied duty to market remains the same. It's Kansas law.
No,
It's
I
not
understand.
fact specific.
Yeah, I think we're talking across each.
Okay, maybe I'm not connecting with you on that, Your Honor, but the implied duty to market remains the same throughout all of those leases because that's Kansas law, and Kansas law can't apply differently its implied duty to market for one lease than another.
Why can't it if the terms are different? I think
Because
that's the point here, that if the lease has got value at the well, or market value at the well, or net proceeds or gross proceeds, all of that's going to inform what the implied duty is that comes out of this contract. And that gets me back to my first question, which is just because it was sold downstream doesn't mean the terms of the lease, the facts that it's happening are irrelevant to what to how you're going to value getting the proper royalty payment to your clients.
So that issue I don't think really was briefed very well to the court because it's not an issue that was certified to this court. But with respect to the implied duty to market, as I indicated, whether it is a proceeds lease, whether it is a market value lease, whether it's a Wachter lease, the three main types in Kansas, they all have the implied duty to market. And the implied duty remains.
Well, every contract's got an implied duty.
No, not a good faith implied duty, an implied duty to market, which means the duty to get the best available price. Imagine if producer was faced with 6,000 leases, maybe 20 or 30 in one particular well, all of them somewhat different, and the producer had to say, well, with respect to this lease, I need to market that gas in one way, but 3 other leases in this well say I have to market the gas in a different way. They couldn't do that.
But aren't you saying that once the gas is sold, that defines what the implied duty was? in that particular lease, regardless of what the terms are.
Not exactly. The implied duty to market is embodied within every single lease, and that's what defines the duty to do something on the part of the producer. And that unified duty is to get the best price available. The second one is mutual benefit rule. And the third one is to do all the preparation for the gas at their sole expense. In this particular case, they have that implied duty in all of the leases, and consequently, they fulfilled their job here by getting the best price available, as they pointed out in page 2 of their brief. And so consequently, they needed to they needed either change the law here, which means they wanted capable of sale rule, which is changing faucet, wipes out 60 years of law of this state, and has never been adopted by any marketable condition rule state, or they would have cited it. Or they have to change the facts.
But their argument, as I understand it, or at least one of their arguments, is that the sale contract that they had might be evidence, would be evidence of something, but they actually, by entering that contract, exceeded what their duty was under the lease, and they enhanced the recovery or the royalties or the amount, the proceeds that are coming, which benefits everybody. That's the way I understand a good part of their argument.
If that's their argument, it would be contrary to the law.
So why is that wrong, though?
Oh, because the marketable condition, you have to first get the gas into marketable condition, and then after that, there's an enhancement issue. And so the marketable condition is really about the issue of what happens in that midstream space: gathering, compression, dehydration, treatment, and processing. So those are the issues. Those are the things that they don't enhance any product that comes out of the ground. The raw gas comes out of the ground with methane, ethane, propane, but also with CO2, nitrogen, and a whole bunch of other things.
Why isn't that a fact question?
It's not a fact question. It's a fact. It's just an ultimate fact that the gas, when it comes out of the ground as raw gas, has a lot of constituents that need to be pulled off to make the hydrocarbons fungible and in marketable condition. Now, some wells are different. Some wells come in and they have 35% methane. So it's going to be very difficult to make that well, the gas from that well, into marketable condition. Some start out at 90%. All of the raw gas is considerably different, which is why you don't have a market for raw gas. Consequently, these things that have to be done, separating literally the wheat from the chaff, you have to separate the bad from the good so that the good can be marketable. So that's the question. Capable of sale rule, I'm about out of time here. That would change all of the law. And the facts that they want to impose here do not exist. We do not have irrigation gas in this case. We don't have farmhouse gas in this case, and we don't have any wellhead contracts in this case. So with respect to faucet, this case would be decided very similar as to what you would see in Cooper Clark versus Oxy, because that's the nature of the contract that they chose to enter into, and that's what is being used to market all of the gas from the 6,000 leases under the implied duty to market.
I have two quick questions. I hope they'll be quick. One is just sort of a fact, maybe relatively unimportant, but my notes show that 8 of the 6,000 odd leases have express deduction clauses. Is that right?
That is correct.
I understood you to say that none of them did. Did I misunderstand that?
That's because they're excluded from the class.
Okay, so we're not talking about those.
We're not talking about those. We know that the parties know how to exclude their leases from that implied duty to market, and some of them did, but it's rare. It doesn't.
But from your perspective, those 8 leases are not part of what's in front of us.
They're not, because they're not part of the class.
Okay, and then my second question is just very concretely with respect to the actual question that district court certified to us. How do you want us to answer that question?
I want you to answer it that it has to be based on the real facts. It can't be based on facts that
Well,
don't exist.
but that's not really an answer to the question. I'm asking you to put yourself in our, you know, put
Right.
yourself up here. You get to answer for your clients. What answer do you want us to give?
Well, it would be that second prong rather than the first prong.
So you want us to say that the lessee, and I'm quoting from the question itself, the lessee's duty continues until the gas is in such a condition that it can be sold in the market in which the lessee intends to sell and actually does sell.
Right.
That's what you want us to say.
So to Justice Biles' point, whether it's intended or whether it's contracted, it's where he actually does sell. It can't be theoretical, but we have to deal with real facts. Breach of contract claims are based on real facts. They're not based on imagined facts.
That's why you don't think that is that the factual question that varies, is where the gas was actually sold?
Absolutely. You've
Rather than I understood the earlier questions to go to the factual questions that may vary are pinned to the variances in the lease language.
That's correct.
Well, is it the lease language or is it where the gas was actually sold?
It's
or both?
It's the gas contract that really carries the day for Fawcett. And so as this court knows from not only Fawcett, where there were wellhead contracts, but also from this particular case where there aren't any wellhead contracts, it's fact dependent on what the contract is that is at issue before the court.
Okay.
So those can vary. And because they vary, the court needs to be able to analyze the particular gas contract at issue.
And that we're talking about when the gas contract is not the same as the lease, just so I understand.
That's absolutely correct.
So you're
Because-
saying it's the variance in language in the gas contracts that matters,
That-
not the variance in the language of the.
Well, the variance in the leases could matter, as you pointed out, Your Honor, that if there's an express deduction lease, then that is in a category by itself because it does not have the implied duty to market. It's expressly excluded. So the only unifying thing between all of these leases that have slightly different language were entered into in different years and by different lessors and lessees over a period of time is the law of Kansas, which is the implied duty to market. But outside of that, the parties are allowed to contract outside of the Kansas law on that issue. And some did, most don't.
Can I have you help me understand how the answer to the certified question plays out with some of the leases hypothetically? As I understand, at least based on one affidavit in the record, the majority of these leases base royalties on market value at the well, and the actual royalties were calculated from downstream sales minus midstream costs. Okay, so you've got what was paid, and then I'm just confused about the market value at the well provision in the leases.
Sure.
Where's the breach of the implied covenant come in based on the answer you would have us give to the certified question?
So many of the leases have the at the well language and whatever.
Market value at the well.
Yeah, market value. Some of them have proceeds at the well. Some of them just say at the well. Regardless, all of the gas is measured at the well, both quality and quantity. And you're going to get paid for that based on what the market value is. So then how does that get monetized? It gets monetized by sales through a gas contract between the operator or the producer and somebody who's willing to buy that gas. And that somebody here is a company called SEMA, and they are willing to buy gas after it's processed. There might have been people willing to buy it before then, before it was processed. Let's assume that's the case. Scout wisely, to their credit, said, we're skipping over all of those because we want to get the best available price, not only for ourselves, because they have 7/8 of all of the gas, but for our royalty owners as well, they have 1/8. So that is the place where that market value is determined. Now, with respect to Justice Stiegel's point, or the express Deduction leases, those express deduction leases are between the royalty owner and Scout. And they say, we get to deduct all of the following, or some of the following: gathering, compression, dehydration, treatment, processing. Then they get to, because that was their deal. If they don't have in the lease that they get to deduct those kinds of things, then the implied duty to market kicks in and they don't get to. So this court was faced with the issue in the 1960s. What do we do with those leases that are literally silent on what you can deduct? And they imposed the implied duty to market that says the onus is on the oil and gas company to get the language that says you can expressly take those midstream deductions. If you don't have that language, then you don't get to take those deductions. And Texas, for instance, is just the flip side of that. In Sternberger, this court said we're not going to follow Texas law. Texas flips it and says, if that in those silent leases, if you don't, as the royalty owner, get the language that expressly says they cannot take those deductions, then they get to. So that's the way in which the courts have decided that issue. Implied duty to market, marketable condition rule applies in many states: Colorado, West Virginia, Kansas, Oklahoma, federal government, Wyoming by statute, and some follow the Texas rule. So that's where we're at on that particular issue, and that's why the leases are homogeneous with respect to implied duty to market, non-homogeneous, as Justice Stegall pointed out, with respect to express no deduction leases. I see I'm out of time. I appreciate it. Thank you.
May it please the court, Robert Kirkendall on behalf of the Scout entities. The court is correct. This is a breach of contract action. The ultimate question is whether the Scout entities paid the contract royalties under the term of the oil and gas lease. Now the leases are many and varied, and each has an influence on what the royalties need to be.
Mr. Kirk, I'm
Yes.
sorry to interrupt you so early. But I think the last statement that counsel made might help focus the argument. And what he said is, the rule ought to be, if you don't have the express language about deductions in the contract, you don't get to take them. Why is that wrong?
Well, Your Honor, that conflicts with a number of different cases in Kansas. The Fawcett cases, the Coulter versus Anadarko cases, the Sternberger case, and others. It goes back to even the market value cases back in the late 70s and early 80s. Those cases tell us what the language of the contract means and how it should be interpreted. And contracts that say you pay based on a market value at the well mean you pay based on a market value at the well. Now, the whole intent or the whole purpose of the plaintiff's attempt to create this the intended market theory is to escape the terms of the language of these leases and escape the valuation points selected by the people to these leases and impose something that is not consistent with Kansas law. We've heard some talk about Fawcett versus OPEC. This is the latest word on a producer's duty to market and the implied obligation to make gas marketable. In those cases, the gas was sold at the well, and those cases were an easy case. It said proceeds for gas sold at the well. This court held you pay based on proceeds for gas held at the well. Those leases are what is termed Wachter leases. They had two specific contemplated cases. One, for when the gas was sold at the well, you pay based on proceeds. The second case is what we are dealing with here, where what the gas was sold someplace other than at the well. And these royalty clauses say, under those circumstances, the ones we are dealing with here, you pay based on the market value of the gas at the well. That's what we are dealing with here.
Part of my, so when we had Faucet One, you
Yes,
two lawyers were here. The gas was sold at the well. Mr. Sharp's position was pay no attention to that
yes,
because this gas is supposed to be out in the interstate pipeline and that's the quality.
yes,
Okay, fine. This case, we've got the gas being sold downstream,
yes.
and you're saying pay no attention to that. It's got to be valued some other way. And I feel, in these royalty cases, I feel like we're playing fantasy football, that there are just all these other hypotheticals other than the reality that's there. And the reality is the gas was sold downstream. So why isn't that where we plant our flag and start analyzing whether you're underpaying or overpaying your royalties?
There is nothing inherently wrong with planting a flag at that point and using that as the starting point in determining what the value is. And in fact, that is what Scout does. It bases market value at the well upon what it receives in terms of proceeds from the sale at the plant, but it deducts the fractional share attributable to the royalty owners of the costs incurred to get it to that point.
But why do you get to do that?
Well, first of all, there is a viable market at the well. Scout could sell to other producers like Faucet. Gas can be sold and is frequently sold at the well to other midstream companies. And in fact, the OPEC Faucet gas, some of that was sold to Scout, commingled with this gas and all processed at the Jayhawk plant.
Well, that's kind of the fantasy football part of this. You're saying we could have sold it here.
We could have.
But you didn't.
That's correct. Because this is where the alignment of the interests of the producer and the royalty owners really play an important role. Scout determined that it could get a better price, more money for the gas if it sold it elsewhere, even if it incurred the cost to get it there. Now, Scout gave the royalty owners the same deal that they were getting. The price, the better price at the end of the well, but they required the royalty owners to pay the cost of getting it to that point. Now, this is the enhancement rule, and the enhancement rule was discussed expressly in the court's case of Coulter versus Anadarko. This was a case which pitted two royalty owner class attorneys against each other. Mr. Seeley, who submitted an amicus brief for the Southwest Royalty Owners Association, sought court approval of a settlement. Mr. Sharp opposed that because that settlement did not value the gas at the way that he wants it valued in this case. But Mr. Seeley testified at the approval hearing that the marketable condition rule has never been interpreted to require a producer to pay royalties on enhancements, which it elects to perform to marketable gas, such as by extracting natural gas liquids. Now, the court upheld Mr. Seeley's position, saying that the lessee must bear the entire cost of putting the gas in condition to be sold pursuant to the court-made marketable condition rule. And that's an obligation that Scout fulfilled.
Let me ask you a quick question just for clarification.
Yes.
So when When Scout, pulls it up and then they send it to a third company for processing.
Well, no, they are vertically integrated. They have their own gathering systems, their own extraction plants, and they own the Jayhawk plant where gas is processed, the liquids are taken, and the residue sold, and the liquids sold. So it is
Okay, it's all of them.
Scout.
Okay.
Yeah,
Thank you.
yeah.
Can I just see if I'm understanding your argument correctly? It seems to me that if I'm understanding the argument correctly, you're really just wanting to look at two data points for most of these leases. Market value at the well.
Yes.
Which I'm assuming is a fact question. Experts could probably come up with whatever. It's a fact
Absolutely.
question. You can come up with a number at the well. And then, but that's not what you paid. You paid downstream sale price minus the cost to get it
Yes.
to that at that market.
Yes.
And so those are our two data points. And if the payment that was made ends up being less than market value at the well, you've got a problem.
Correct.
But if not, that's just how you would interpret the plain language of these leases.
That's how you would interpret the plain language of most of the leases. I mean,
Correct.
there are much different terms in some of the leases. Some of the leases require payment on gross proceeds. A gross proceeds lease where the gas is taken and treated will yield maybe a different result. But most of
Correct.
the cases are this market value.
But then okay, I think we're on the same page. Then it seems to me that you would want us to answer the certified question as neither as well. Because it depends on the terms of these leases, right? Whether it's at the well, whether there's express terms that allow deductions, whether it's gross proceeds, and whether those gross proceeds are at some other market or at the well.
The ultimate case depends on those things, but as to the marketable condition rule, the court can simply say that a lessee's duty to make the gas marketable at its own expense ends when the gas is in such a condition that it can be sold in a good faith transaction, regardless of when or where or if it is actually sold.
So it's basically your position that if a product can be sold, it's marketable.
In a good faith transaction. And in this case, there's no question that this gas can be sold at the well because there is a thriving market for sales of gas at the well in the field. And in fact, Scout is not only a seller of gas in that field, it is a purchaser of gas in the field.
Does it make sense from your perspective to articulate it this way? Your position is that the marketable condition rule is a rule about valuation, whereas your opposing counsel's view is that the marketable condition rule is a rule about sale. Am I oversimplifying by saying that?
I think you almost have that backwards. The marketable condition rule means you've got to treat the gas in such a way that you can get it sold.
Right. Your
somewhere.
position is the only thing this rule requires is that we pay royalties based on its marketable value anytime it can be sold.
Correct.
And that's at the wellhead usually.
Correct. So the
And
marketable-
the opposing view is no, the marketable condition rule says we get royalties based on when you actually sell it. No, it's not about valuation.
That's
It's
correct.
about selling it.
That's correct.
Okay.
And if they had gross proceeds leases, they would be entitled to that, perhaps. Gross proceeds meaning what we get for the sale of the gas, when and where we sell it. And that is not what the terms of the language is.
Aren't the terms just silent? And why doesn't that work against you as as we interpret the contract? why is the fact that you've left out the deduction provisions not work against you in that way? If you decide not to sell it at the point where you could in good faith market it, which is clearly under the contract, but you choose to market it at a downstream point, but you have not clearly stated in your contract how those deductions will be handled or how those costs will be handled, whether they will be deducted or not, why does that not work in favor of the lessor?
Well, as a practical matter, these questions never arose when the leases were first drafted and put into effect. We're talking about old leases here that were signed well before these issues were an issue. So nobody would have anticipated this. And later leases, you do see the express language provisions, and you do see the gross proceeds provision that provide what the plaintiff wants. But we do know how these contracts have been interpreted over the year. And we do know this from the market value cases that were decided in the late 70s and early 80s. And in these cases, the market value clause interpreted was this very royalty clause. And in those cases, even though the gas was sold at a point, well, at the well, but at a cost different than what the fair market value was, the court held, you look at the market value of the gas at the well in a hypothetical market. The market is the descriptive of the buyer at the outlet for sale is not synonymous with its larger meaning in fixing price or value. For the situation, the law looks to the particular transaction, but to the theoretical one between the supposed free seller vis-a-vis the contemporary free buyer, dealing at arm's length, supposedly in relation to the property, where neither will ever own, buy, or sell. It is not an agreement to pay based upon an actual price for sale. Now, this is how this royalty clause has been interpreted before. Now, no one has ever come up with an intended market rule dealing with marketable condition until Mr. Sharp decided to come up with this one. And I would submit that the entire case really resulted from two ill-chosen words in a Court of Appeals decision. Before the Cooper-Clark case, there was no intended market theory. And the law about calculating royalties when the gas was sold off the lease was well decided under the other cases we've talked about. The Sternberger case, where gas can be marketable at the well, even if there is no market there.
And I assume some of these leases include market price at well language.
Oh, yes.
Do they all include that?
Most of them include market price at the well for gas when it is sold off the well language. It might not be 50%, but it is close.
Is it your position that all gas that comes out of the well is in a marketable condition?
No, absolutely not. There may be some treatment required in order to inject that gas into even a gathering line. You know, it could be that wellhead compression is required to get it from the well into the line. And the court's decision on that is clear. Wellhead compression is an expense borne by the producer. It could be that the gas is sour and it requires some chemical treatments before it can be sold or before a buyer would take it. Those things are required to be done. It could be it's wet gas, needs to be run through some kind of a wellhead separator to get out the water. Those are all treatments that are the responsibility of the producer in order to provide a product that is marketable at the well. And those we don't charge royalty owners for at all.
And determining marketability at the well, would that necessarily be in a commercial setting? I mean, I can see somebody saying, well, we could sell it for, some minuscule amount to use for irrigation purposes or something like that. So that's actually the value. And the fact that we are getting it into the commercial system that has greater value, that's all, we share all those costs. That there's some real low ball kind of use at the well that you would be able to seize on to try to do this on the cheap.
Yeah, trying to do it on the cheap doesn't pass our test. We require that there be a market value,
Commercial.
a commercial market value, a contract that would be a good faith contract for sale.
So what actually are the costs that you want to pass on to the royalty owners?
The extraction costs require, an energy expenditure. It requires a compression and.
Well, I'm looking at Sternberger, for example.
Yeah.
And that was dealing specifically with transportation costs.
Yes.
To the downstream market.
There are transportation costs in getting it from the gathering to the processing plant, and then there are.
I guess what I'm driving at is you've just gone through a litany of activities that can be performed on the gas to make it more valuable at the wellhead. You just talked. Couldn't recite them, but you listed some.
Those activities are even necessary to make it a marketable product to get out of the well,
right,
to somebody who would.
So what are the value added things that can be done to the gas that you want to be able to deduct those costs downstream?
Okay, you transform the gas into a final product which is fit for transportation to the end user. You can sell it, you sell it at the tailgate of the plant to somebody who will take that gas, put it in a pipeline and shove it all the way to Chicago where it is burned at the burner tip. It takes some cost and expense to get the gas from the raw gas in the field to that point. But along the way, you withdraw various components of the gas, propane, butane, other liquids.
And those are things that you wouldn't have to do if you sold it at the wellhead.
Correct. And in Fawcett, some of the contracts for sale of gas at the well do provide for a computation of that price at the well based upon, in part,
okay,
the proceeds.
So is it fair to say that you want to extend the Sternberger rule past mere transportation to include these other activities?
I wouldn't put it that way because I think that the rule we're proposing is absolutely consistent with Sternberger and Coulter and Fawcett.
But would you agree that Sternberger dealt only with transportation expenses?
That was apparently the only expense.
I'm just asking you, what you're saying is that there ought to be other expenses that are treated the same way.
Absolutely.
I want to steal Justice Stiegel's question. How do you want us to answer I guess I want to go back and I want us to answer the question posed by the federal court.
I think that you answer simply that a lessee's duty to make the gas marketable at its own expense ends when the gas is in such a condition that it can be sold in a good faith transaction, regardless of when or where it is actually sold. So if we can sell it at the well, we need to do what's required to make it saleable at the well, but no more. Thank you.
Let me begin with the gas contract issue in Sternberger in particular. The gas contract here can either be determined based on what really happened in a breach of contract case or based on something that didn't happen. How a defendant gets to come forward and say, well, we didn't really breach because, well, we did, but we could have done something different and not breached. Well, that's not a defense that I think can be done. With respect to gas contracts, you have to look at what really happened.
Well, let me just ask with respect to what really happened here.
Yes.
Are you asking as part of your damages in this case to recover the royalty share of the transportation expenses?
No, because transportation is not at issue in this case.
Why
Only-
not?
Only processing deductions are at issue in this case. Scout, or actually Scout's predecessor, has already settled the issue of deductions of gathering, compression, dehydration, and treatment. Those were settled in prior cases, those midstream types of expenses.
So just,
So just processing is at issue here. The processing is done by Scout at Scout's own facility.
but don't they have, I mean, if I understood correctly, the Scout is claiming that there were some expenses associated with moving the gas
Yeah.
from the well to the processing facility.
Correct, that's called gathering. And so that's already been settled, and we're not disputing that issue. It's settled up and long since gone.
Okay.
All we have is processing at the Scout facility. So they're asking us to pay for some of their processing expenses that they incur themselves.
So you're not trying, the needle you're trying to thread is to disallow these other kinds of deductions without disturbing the Sternberger rule.
Exactly.
Okay.
So in Sternberger, in the third syllabus, the court said, absent a contract providing to the contrary, here the contract being a lease providing to the contrary, a non-working interest, meaning a royalty interest owner here, is not obligated to bear any share of production expenses such as compression, transporting, and processing undertaken to transform gas into a marketable product. The reason they use the language production expenses is not that this is what you would see production of gas to the surface at the well, like drilling cost, lifting costs, or separating the gas that happens at the well. Even under Texas law, they can't take those deductions. But under the implied duty to market states like Kansas marketable condition rule, they have to produce a marketable product. And that marketable product is determined by the midstream services that have to be done. Here, those midstream services were gathering, compression, dehydration, and treatment already settled. Their predecessor already paid for taking those deductions. They realized that they couldn't really make a sale at the well like they claim they would like to be able to do here, and they weren't, and therefore they paid for all of those midstream services. The next one on the list is processing, and they're taking that deduction at their own processing facility that Scout owns.
Out
So-
of the other marketable condition states, has this issue been resolved?
Has the processing issue been resolved?
Mhm.
Yes, I think the issue has been resolved right here by Sternberger, where it says that's a.
No, I
produc-
mean the other states that you're talking about.
Oh, yeah, absolutely.
All in your favor? All in-
Oklahoma decided in our favor in Pummel. West Virginia, the most recent West Virginia case, decided it in our favor as well. Colorado has decided in our favor. Every marketable condition rule state has done so. And the reason is because it takes things to separate the gas. You're not enhancing the gas. You're not adding anything to it. You're separating the methane from all of the other stuff that's imbued with that methane when it comes up out of the ground. You have to get rid of the CO2. You have to get rid of the nitrogen that won't burn. You literally have to get rid of the water vapor. That's the dehydration piece of it. You have to compress the gas, otherwise it's not going to move. So all of those things have to be done, but you are not changing the molecular structure at all, like you do in oil. When you hit a refinery, you change oil into gasoline. You enhance the value of that oil into gasoline, into jet fuel, into other things. You don't do that here.
Would you agree that if the gas in question had been sold at the wellhead in a good faith transaction,
It'd be,
that you would,
be a totally different case. We wouldn't have, then the pre-sale expenses and the
the-
post-sale expenses would be totally different.
right, but the Scout would have complied with the marketable
It-
condition rule.
It would be a Fawcett case then, as opposed to a Cooper Clark versus.
So you're really focused on what happened in reality. In other words, maybe I'm being ham-fisted, but you view this as a rule about when the sale happens, as opposed to a rule about how do we value the gas.
We look at how it is valued.
Right.
in
You want
reality,
to
not
say,
In theory.
forget all the valuation experts. None of that matters. The only thing that matters is when you actually sold it.
What really happened in this case. I totally agree with that.
And how does that reconcile then with the at the well, like market value proceeds, whatever, at the well language?
And I'm glad you raised that issue because Sternberger grappled with that at the well language. And I want to say that Mr. Kirkendall is correct about what happens about these silent leases. At the well doesn't tell you whether you can deduct gathering, compression, dehydration, treatment, or processing. Doesn't tell you anything about that. So in Sternberger, that had to be dealt with. And in Sternberger, this court said, at the well doesn't tell you anything about that. It's silent as to whether you can take those deductions. Mr. Kirkendall's point was, but there were lots of leases that happened in Kansas before 1964 that were silent. All they said was that at the well, they didn't have any of those deduction languages in there. And so consequently, who is going to have to decide, are those express deduction cases or are those not allowing deductions? In Sternberger, the court said, it's not ambiguous. At the well doesn't mean you get to deduct or it doesn't mean you get to deduct. We have to establish a rule. And the rule is going to be this. The oil and gas companies know what they're doing. These are oil and gas forms and leases. And they've known for a long time what they're doing and how they do what they do after the gas gets out of the ground. Farmers and ranchers and widows, farmers and ranchers, they don't have any idea what's in their form lease. So if you want to take those deductions from those farmers and ranchers and widows, you have to say so in the lease. And after 1964, there was no doubt that's what they had to do. And as Justice Stegall made a point, it happens. It's pretty rare because if you present somebody with a lease and says, oh, we're going to pay you 1/8 of the market value, minus all of this other stuff, they go, well, wait a minute, minus what? How long is that going to be? And how much is that going to be? And does that last forever for like my entire generation and generations on? No, we don't want that. We want just a plain market value lease. We don't want all those deductions. So it's hard to get those kind of leases. Sternberger made clear that they weren't adopting the at the well valuation method of Texas. They didn't feel like they were treating the royalty owners correctly and the mineral owners weren't getting their fair shake. They put that onus on the people who did the form, which is consequently the reason that oil and gas leases, kind of like insurance policies, are construed against the people who draft.
It's kind of a rule of interpretation in the face of ambiguity that these royalty owners are not the drafters.
That's correct. And so Sternberger has addressed that issue completely. And so the lease issue really isn't the issue here before the court. That was the certified question to the court. The question really was, are you going to base the decision on whether gas is in marketable condition based on the real contracts that were at issue in this case, or something theoretical, as they say, capable of sale rather than what they actually did? And the capable of sale then just boils down to a theoretical, oh, we could have done this, we could have done that. But don't forget, not a single contract, wellhead contract or irrigation sale is just one farmer and one producer. But with respect to a gas contract at a well, at the wellhead, you've never seen one that involves 3,500 wells. I never have. I don't think there's anyone that exists. This is a really large volume case concerning 3,500 wells. ever seen a wellhead contract like that. Don't expect I ever will. And consequently, this gas, this huge packet, dedicated gas, could not have been sold at the wellhead. But it's not what I say, it's not what an expert says, it's what they did. It's the contracted for, intended, chosen market that really matters. That's where the breach was. They needed processed gas to meet that gas quality, so we can't be suffering deductions for processing. The gas needed to be processed.
On your references to West Virginia and Oklahoma supporting your position, and it's been a couple of days since I looked at those cases.
It's been a couple of days since I've
And
looked
I've
at
slept on them. I've slept since then, so.
I
remember.
believe,
But
the Taney case in West Virginia. the
West Virginia had a statute, though,
Yeah.
right?
West Virginia has what?
A statute.
They
that
do have some
impacted this
statute.
Analysis. And then in Oklahoma, my memory is that, and you were counsel there, that you lost the commonality issue on the fact intensiveness of the, you were using the intended market argument, right? Am I remembering that right?
No, actually, we won that over in the Eastern District of Oklahoma in a case. It was against a Cimarex affiliate, Magnum Hunter, I believe it was called. And they of course followed Judge Maritz's ruling in the 10th Circuit that also followed Oklahoma law on that subject. And it really does use the intended market theory, which Your Honor, I think probably correctly just said was the contracted price theory.
I came across an Oklahoma case looking for references to Fawcett. And so we might be talking about different cases too.
They have not adopted Fawcett, Your Honor.
Yeah, okay.
Oklahoma has not adopted Fawcett, and West Virginia has not adopted Fawcett. Fawcett and Sternberger actually, Sternberger is the differentiator between Colorado and West Virginia law on marketable condition rule, because they require you to actually get the gas, meaning transport the gas all the way to the market location if it's already in marketable condition before it gets to the market location. Sternberger says that's not required. Thank you very much.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. Court is in recess until 9 a.m. tomorrow.
All right.